This episode is presented by Recovery Centers of Montana.
If you or someone you know is struggling, getting help shouldn't feel out of reach.
Recovery Centers of Montana offers care across 6 locations, including inpatient facilities and outpatient clinics.
Step away from the noise and focus on getting your life back on track.
Learn more by calling 701-401-3000.
That's 701-401-3000.
North Dakota Farmers Union.
North Dakota Farmers Union makes family farming and ranching their business. So while you're working hard, Farmers Union is working just as hard to address issues that impact your bottom line. Everything from high input costs and trade tariffs to market concentration and a new farm bill. Farmers Union is the organization led by and for family farmers and ranchers. If you aren't already a member, join them at ndfu.org.
North Dakota Farmers Union.
Hi, I'm Megan Invick with Americans for Prosperity, North Dakota. Rising property taxes are putting pressure on homeowners across our state. While recent relief is a good start, families need permanent solutions, not temporary fixes. That's why AFP North Dakota is pushing for meaningful, permanent property tax reform, so homeowners can plan for the future without worrying about being taxed out of their own backyards. Learn more about the road to opportunity and our plan for property tax relief at afpnd.org.
Everyone, welcome to Plain Talk. Before we get started, we have Chris from the Forum for some North Dakota trivia. Chris?
Dwayne Klee, that's spelled K-L-U-E-H, was the first person born in North Dakota to do what?
Well, it wasn't to be a Supreme Court justice. It wasn't to be somebody who's gone to space. I'm going to go back to sports. He was the first guy to play in a professional golf tournament from North Dakota.
Okay. Rob, you got a guess? Dwayne Klee.
Oh, man. I give up. I have no answer. I don't know.
Dwayne Klee was the first person born in North Dakota to play in the NBA.
Oh, I was thinking that was going to be my answer, but I feel like I would have known that.
1949, he was drafted with the Boston Celtics. He later went on to coach, I believe, for like 10, 12 years at Indiana State University. If you're listening, viewing the show, and you are curious about our great state of North Dakota, and you appreciate the work these fine fellows do, please consider a subscription to the Forum. Visit us at inforum.com for our introductory rate of just $6 for 6 months.
I just spilt copy.
You're listening to Plain Talk, the voice of North Dakota politics. I'm your host, Rob Port. If I sound distracted, it's because I've been busy covering this story all morning. I'm joined by my co-host, Chad Oban.
He's right of center, I'm left of center, both sides of the political spectrum.
I think it's cathartic. I think it's a necessary and proper debate. I'm glad we're having it.
And honestly, we have to do better.
Okay, I don't know why I'm getting blamed for this, right? Welcome to Plain Talk, where it's apparently Judicial Week. We had Supreme Court Justice Jerod Tufte, who's up for re-election this year. He's going to be on, or he was on the Wednesday show. Now we're going to have his opponent, Ariston Johnson, Ari, who is a attorney practicing in Watford City. He is a general counsel for the McKenzie Electric Cooperative. He is a senior assistant state's attorney for McKenzie County, and he is running for the state Supreme Court against Jerod Tufte. Now, Justice Tufte, Mr. Johnson, let's start there. Why are you running for this office? What inspired you to get in this race?
Rob, first, I want to say thank you for having me on the show. It's an opportunity to speak to people that I wouldn't otherwise have holed up here in my office in Watford City. So I decided to run for election to the state Supreme Court because I believe that our court system is better with a broad perspective, if every member of the team has something to add to the conversation. So you have justices from different backgrounds, they have different things to add, and together they can understand things better than any one person could. My perspective comes from 2 decades in private practice in North Dakota, 4 years in Bismarck, and the past 15 years here in Watford City, which is my hometown, including a wide variety of civil law cases. I do estate planning and probates. I do insurance disputes. I do land disputes. A lot of oil and gas law, of course, here in oil country, from writing a lease to litigating what goes wrong when the lease doesn't work out. I have experience in criminal prosecution and a lot of local government experience with zoning boards and whatnot. If you look at my resume, I'm a true general practitioner, which is something that maybe is going the way of the dodo, but it's important because our courts have general jurisdiction. There's not a different court for oil cases or divorce cases or criminal cases or anything else. They all go through the same court system. So a justice with that broad perspective gained from significant experience practicing the law with clients, with local governments and companies, going to court for them and explaining, court's the tip of the iceberg. An appeal is the tip of that tip of the iceberg. The rest of the iceberg under the water, under the surface, is what a lawyer deals with his clients for months before a case goes to court and for months afterward. I feel that broad perspective from my time in practice will be valuable to the court and then valuable to North Dakotans who benefit from a court that understands the entirety of the law.
I see in your background that after spending time in Grand Forks and at UND that you're a red pepper fan. So it shows you have good taste, right? The interesting thing that I see is that, North Dakota generally doesn't have challenges to us or elections, for challenges to a sitting Supreme Court justice. Once in a while it happens. You're choosing to do so. And obviously you've had a desire to be on the court. You sought the appointment from the governor, and now you're seeking, the election. There's another Supreme Court justice up for election as well. How did you choose, I'm going to run against Justice Tufte or I'm going to run against Justice Bahr? Did you see a vulnerability in one versus the other, or how'd you choose to pick that particular slot to run for?
Governor Schaefer, you've asked what lawyers call a compound question. I'll try to answer each part of it. Most importantly, I've had good taste since I was very young, visiting my mother's family in Grand Forks. We'd go to the Red Pepper on the way into town at my insistence, possibly somewhat inconsiderate of my grandmother cooking a nice meal that I was no longer hungry for after my salami grinder. About judicial elections, contested Supreme Court elections are fairly uncommon in North Dakota. I think that they were more common in the past. I did a bit of a self-survey of past election results. There have only been a few that I can think of in the past 25 years, and maybe that's a credit to governors appointing very good justices starting in the 90s, if not earlier. But as to deciding which seat to run for, it's not so much a vulnerability as a strength in the court that I want to see. So when longtime Chief Justice, and then Justice VandeWalle retired, I did not apply for that opening because it's not that the shoes are too big to fill. They certainly were, but it's a perspective that I couldn't offer, that lifetime of state government service. And I think that Justice Bahr is a very good fit for the court because he brings that perspective, decades as a government lawyer before he went on the bench. I think the court needs that because the state is a party or interested in so many cases that the court decides. And without that perspective, the court would fall short of being its best court. Frankly, if the election ballot offered Ariston Johnson or Douglas Bahr, I could vote for Douglas Bahr because the court needs that perspective. That's one reason. Another reason I chose the seat that I'm running for is that it's a complete 10-year term, and I would prefer to serve 10 years, a full term, than the 8 remaining on Justice Bahr's term. So that's how I picked that. It's not so much a vulnerability as wanting the strongest court possible. And frankly, I think that regardless of the outcome of the election, which I hope to win, but more importantly, I hope it brings strength to the court system as a whole. I think that my perspective can rub off on the court system without being on the court. I hope to bring it inside the Supreme Court, but if I don't, maybe people will listen, and maybe what I have to offer can still be offered.
Whenever I do interviews of judges or judicial candidates, the interesting thing that comes up that I think and I'm glad it comes up every time, because I think it gets overlooked by the public. We think a lot about, how would they rule on this case or that case, and I realize that you candidates are going to talk about that, but that's obviously going through the minds of the voters. But the other part of it is the administration of the courts. And, Justice Tufte has talked about his computer background. He's certainly done work during his 10-year term to modernize the court, in terms of public access, grappling with some of the realities of AI. One thing that he mentioned during his interview that I hadn't even thought of was that access to AI legal tools is gonna create more work for the courts, because more people are going to be willing, theoretically, to file actions or to file with the courts, because they have all these tools available that kind of make more accessible. And on one hand, that accessibility is good. On the other hand, it's a lot more work and a lot more jurisprudence. You have a background in computer science. You actually have a computer science degree from the University of North Dakota. So talk a little bit about that, modernizing the courts, or what that technological aspect would look like in this office.
Rob, that's a good question. I think that viewers should know one thing is that we're recording this before Justice Tufte's interview has run, so I don't know what his answers may have been. Or
that's fair. Yeah, and I'm not really pitting you against each other. That's fair.
And I just I know you're not doing that. Mostly I don't know what he said, and if I'm echoing him, it's because things are generally true. Technology is always an opportunity, but it's always a double-edged sword. So AI in particular, the court, modernizing the court is a strange way of putting it. Our court is fairly modernized. There are things that should be brought into this decade from a couple decades ago within the court system, but by and large, we are a modern court. AI raises concerns for me both as someone who sees it coming in from litigants. We, especially in the criminal prosecution area, we see documents that are either generated or augmented with a large language model's input. I've asked these large language models to even take a brief that I've written and a brief that another party wrote in the same case and tell me like which precedent, which case decisions, which statutes are both parties relying on for different things. And it gave me a well-formatted and a well-reasoned response. Every single law in which was a hallucination, even though I had fed it the law. So it's very easy to over-rely on AI that way. And if you're not watching for it, it's easy to be fooled as a judge who takes in thousands of pages of filings in any year, sometimes thousands of pages in a case. So it's something to be vigilant for. It's also something to be vigilant for inside the court. Use of AI, I think, is exciting, but it's also dangerous. It's easy to think, well, there's some menial tasks that maybe AI could do better than a person or instead of a person. The example I always go to is transcription of court proceedings. If you've sat through a day of, say, traffic court or criminal court, you'll hear some very clearly spoken statements on the record, and you'll hear some mumbled statements using non-words on the record. Court transcriptionist has to deal with both of those. A good AI can take the good transcript, the good recording, the good speaker, and make a transcript. But the mumbled one using non-words will throw it for a loop, and you're going to have a human to correct all of that anyhow. Instead of a human doing both it's like a teacher grading A papers and D papers. If you take away all of the A students from the teacher and tell him that you're only going to grade the worst students from now on, it takes a certain amount of the joy out of that job. And I fear that we might make these jobs unpalatable to transcribe.
And that's an issue before our court now, isn't it? That we're turning away from human, we think of the court reporter sitting in the corner taking down everything. We're moving away from that. I think our courts today, now correct me if I'm wrong, this is me thinking I've remembered something, maybe I'm hallucinating, but we're moving towards these automated transcripts, aren't we?
There is a move in that direction. The court knows that it's not there yet. I think it was an interview that you did actually with former Chief Justice Johnson not that long ago that broached that subject a little bit. And it's something that they know
I knew
they're
I
not-
remembered it from somewhere.
from yourself. No,
Yeah.
no. But I think it's an important thing to be cautious about. Not overly cautious. I'm clearly not afraid of technology, even though sometimes I am afraid of technology failing me when I need it most. But obviously, as a computer science degree holder, I'm not afraid of the thing. It's just a matter of understanding its limitations and understanding that, without a human in the loop, there are problems that the AI will get wrong. And if there's not a human in the loop to catch that, watching very vigilantly, things will go very wrong, especially in court. People's lives can be at stake, businesses at stake, family farms that have been in the family since the homesteading days at stake. And if there is, a bad enough issue that the AI creates that nobody catches, those cases get decided the opposite of how they should. And it can all turn on humans not catching their computers pulling a hallucination on them.
You're sitting or trying to sit in a nonpartisan office. Today it drives me crazy. We have so much partisanship in the legal system. We say this is a conservative judge, it's a liberal judge. They're making liberal decisions not based on what the law is. You're seeking a position where you're going to sit there. You're going to have a lot of people trying to influence you as to what you should say, how you should decide. Certainly, they're going to second guess everything you do, but a lot of pressure today with social media and things of saying this is what you should do, letters to the editor, editors even saying this is what's right and what's wrong. Somewhere you have to sit down and say, okay, I got all this stuff. I have to center it off and make a decision. When you sit down and center it off to make a decision, what's your base? Who do you decide, or who do you decide for? Who's your constituents? Who's a constituent to you when you have to make these tough decisions?
So a constituent in this nonpartisan elected position of the Justice of the Supreme Court is all North Dakota citizens. Everyone in North Dakota votes for this seat and has a voice. How they exercise that voice, though, isn't the direct way. You call a legislator and tell them what you think about a bill. You don't call a judge and tell him what you think about a decision or a case. If the people, as constituents, think that a judge gets it wrong, the parties to the case can appeal it to the North Dakota Supreme Court. If that decision is at odds with federal law or the federal constitution, then parties can file a petition to review it in the U.S. Supreme Court. But if the North Dakota Supreme Court is wrong about North Dakota law, the avenue to fix that is through the legislature and the executive branch. So I'm a rule of law person. I don't that judges should be activists from the bench, no matter their politics, no matter their angle. I am myself generally apolitical. I don't bring my politics to work, and I would not bring them to the Supreme Court. It is a nonpartisan race, and it should be a nonpartisan job. If the law compels a decision, then the Supreme Court should make that decision. If the law is wrong, the legislature should write a better law. And only when the legislature has written an unclear or unconstitutional law, or the parties have found an issue that the law doesn't quite accommodate, or it doesn't fit in with the round center bullseye of the target that the legislature was aiming for, courts might have to make a judgment call to interpret the law. But in general, judges shouldn't decide policy and they shouldn't decide law. They should apply the law under our constitutional system with the checks and balances of we have a legislature to correct judicial errors, we have a judiciary to correct constitutional errors by the legislature, and all around the circle with the executive. So I'm hopeful that's a clear enough answer. I'm also somewhat concerned about trust in the judiciary that arises from these partisan discussions. We've got the conservative judge, the liberal judge, the activist judge. What we should
let me jump in, because I was going to
please.
ask you specifically about that. We've seen when we were interviewing Justice Tufte, the example that I brought up with was Wisconsin, where we saw those races become very, very partisan. And of course, at the national level, even right as we were recording these interviews, we saw, the courts hand down some more rulings. They're going to be very controversial. One of them dealing with redistricting, which obviously potentially may touch on North Dakota. I'm not going to ask you about that specifically, but I don't want North Dakota judicial. We talk about how few of these judicial races are challenged, whether it's for district court judges, whether it's for the state Supreme Court. They're usually not very competitive. A lot of times the incumbents end up running unopposed, or maybe they'll get a token challenger. I don't know. They're not very competitive. The flip side to making them competitive, we say, well, they should be challenged. They should be more competitive. The flip side to that is we end up with a circus like in Wisconsin. Now, I don't think that's going to happen with you and Mr. Tufte, having spoken with both of you. I don't think either of you have that intent. But how do we strike that balance where if we're going to hold an election, we need to contrast these candidates? On the other hand, we don't want it to turn into Wisconsin.
Absolutely fair. There was a decision issued today by the U.S. Supreme Court. The news reports said that it came down on party lines. And when you start talking about
we used to not talk about the judges that
exactly,
way, and now we do.
That's a new innovation that it scares me because it also undermines faith in the judiciary as a whole. And so far that faith undermining hasn't infected North Dakota the way it has infected national politics, but all things end up everywhere. If we're not careful, if we don't protect the independence of the judiciary here, we could fall into that trap of having a circus. And Justice Tufte and I certainly would agree that the last thing that we want is a circus. This is an election about judicial philosophy. It's about administrative philosophy. It is about perspective. It's not a race about who's going to decide a certain issue a certain way, because ultimately, as I was responding to Governor Schaefer's question, we shouldn't have that. The legislature should set policy, the executive should follow policy or lead policy, and the judiciary should decide questions of law.
Often you talked about the legislature setting policy. Often legislators will say, well, the court won't let me do that, or the court decided, that I have to do this, or the court, they hide behind court decisions, right? Instead of doing their jobs. How do you deal with that? I mean, how do you flip it out of a decision that's made in the court, say something is unconstitutional law? How do you, because the public pressure is the court made bad decision, right? How do you get it back to the legislative branch where they should be making the policy? How can you push that? Can you go lobby the, lobby the legislators? Can you get the governor? I mean, how do you get it back to where it belongs?
My answer to that for the voter is to elect braver legislators. We have court decisions made that interpret a law that the legislature wrote and the governor either signed or it passed over a veto. And the court decision's made, and 7 years later, the court is still getting questions about what the law means, or parties say, well, that's not what the legislature meant. In 7 years, you have at least 3 legislative sessions, maybe 4, to address that. And the legislature can do that. If it's a question of what a state statute means, the legislature can amend the statute. If it's a question of what an administrative rule means, for example, say the Industrial Commission has an administrative code provision about something. If the court gets it wrong, then the Industrial Commission can make a new rule, or the legislature can make a statute that takes it away from the Industrial Commission and sets what the rule should be. In either event, if it's a question of state law and the court gets it wrong according to the policy, the political and policy come from the same Latin root, and that's because political branches like the legislature should decide policy. They can fix the law so it follows their policy. The exception is constitutional questions, and if our state Constitution is, if the Supreme Court says the Constitution requires something or prohibits something else, the legislature can propose an amendment. The people can initiate a measure to propose an amendment to the Constitution. And of course, the federal Constitution is much harder to amend, but if someone gets that wrong, you appeal to the U.S. Supreme Court. There's always, in the American system, there's always a political path to solve problems if you think that the court got it wrong. Maybe it's burdensome. Maybe it takes a legislator standing up and saying, the court said this, let's fix it. But either way, I think that the court should not bow to pressure, nor should the court give pressure on those other branches, unless it's to say this statute is unclear, it's vague. We wish the legislature would write a better statute. Then the legislature can do that. But pressure between the judiciary and the other branches should be limited to those official channels, in my opinion.
Is it, talking about those official channels, I've often wondered if it would be appropriate for the courts, because when I read, a state Supreme Court ruling, it'll be going down, and often the justices will write in the opinion. The legislature has left a blank spot here. I mean, they use different words, but the legislature is not clear on this, or this is an unclear part of the law, and it's left us trying to fill in the blanks. I mean, they're very candid with it at times in those official documents. Would it make sense before the legislature to come into session for the judicial branch to send a list of open questions, and just, I don't know, put out a press release or something and say, hey, as you come together, here are some blank spots in the law that we've been playing Mad Libs with that maybe we need to fill in some blanks.
Rob, that's a good thought. My answer is that the Supreme Court issues about 250 press releases a year in the form of written case decisions. And each one of those, if it says that, someone should take that to the legislature if they think it needs to be fixed. I think that the opinions are the sole proper way to do that. There are also, though, hundreds or even thousands of lawyers across the state. There are organizations. You've got, police unions here and lawyer clubs there, different groups that can bring these things to the legislature's attention. The State's Attorney Association watches for things like that affect the county and state government questions. You have all sorts of these different organizations that are able to bring those to the legislature in a way that doesn't undermine the faith in an independent judiciary. I think that when the judiciary starts pushing for things beyond what they write in the agreed opinions or the sometimes there are separate opinions that aren't unanimous. It starts to get into that political interplay that I believe in an independent judiciary, and I think that we don't want to undermine that. Like I said, 250 opinions per year, that's the way that the Supreme Court announces what the issues in the law are.
So you mentioned opinion. And of course, that's the terminology we use. The Supreme Court issues an opinion. There's often a constitutional issue about the opinion of the governor or the opinion of the attorney general. The court interacts with the attorney general quite a bit. And one of the issues that I always see is an opinion of the attorney general is equivalent to the law. An opinion of the attorney general, in my opinion, is an opinion, but it has the force of the law. Do you think that the attorney general's opinion has the force of law?
I think that the attorney general's opinion, it falls short of the force of law, except where provided by law. There are places where the attorney general's opinion is essentially a decision on the law. For example, open records and meetings, the attorney general has quite a bit of authority.
I'm just going to say, I've gotten quite a few of those opinions. Generally, I like them.
If you're asking for them, you often would like the outcome. But anyhow, the benefit of the attorney general's written opinions, and there are different areas where written opinions are issued by non-final deciders, by different committees of the court and so on. But as to the attorney general's opinions, they don't necessarily have the force of law, except, again, we're specified. But what they have is they put people on notice that this is the way that the state government or the attorney general at least understands the law. And if it's unclear or if it's wrong, there are paths to fix that. I don't know if there's a reconsideration process for the attorney general. I have not requested many attorney general opinions, but there's always the court system to get an interpretation and a final answer, because the final say of what the law is the Supreme Court. But if the Supreme Court is silent on something and the attorney general tells you what the law is, North Dakotans, especially in government, can work in reliance on that being at least, if not correct, at least arguably correct, so they're not way out in the wrong part of their job, getting it wrong when they could take the advice, not of their own counsel, but of the attorney general for the state. That's part of why it's the attorney general. He or she does do work that the entire state relies on.
Well, Ari, thank you so much for your time today. Certainly appreciate it. And for everybody listening, when you get to that part on your ballots this year that say state Supreme Court justice, and you see a couple of names there that you're like, who are these people? Well, now you know. We interviewed them, so you can understand them and understand the cases they're making for themselves, respectively, for the job. And Ari, good luck.
Rob, thank you. I just want to make a short closing remark, if I may.
Sure,
I want to say
absolutely.
thank you to you and to Governor Schaefer for taking the time to speak with me. For people that don't know, this should be airing on May 1st, which is Law Day in America, which was established by presidential proclamation long ago. And it's an honor to be speaking to North Dakotans broadly on Law Day about this important issue. Like you said, it's on the second page of the ballot, but we're a government of laws, so it should be on the first page of Americans' minds. If you want to know more about the candidates or about the election, there are plenty of resources. I know we both have websites. Mine is johnsonforjustice.org. Also, if we have 17 contested sheriff elections in the state this year, and I've always thought if you want to know about the candidates for sheriff, you should talk to the deputies. In this election, I'd encourage people to talk to those in the legal system, lawyers, clerks, district judges, anyone you know, about what this means to them, because they're going to live under and with whoever wins this election for the next 10 years. So seek out those opinions and seek out more information. be an informed voter, and thank you for your time.
That's great, Ari. Thanks.
Thanks, Ari.
The North Dakota oil and natural gas industry works here, and works here, and here, and even works here by creating 60,000 jobs statewide and generating billions of tax dollars annually to support our infrastructure, flood protection projects, and our schools. North Dakota Oil and Natural Gas, advancing the possibilities.
Learn more at ndpetroleumfoundation.org.
Hi, I'm Megan Invick with Americans for Prosperity, North Dakota. Rising property taxes are putting pressure on homeowners across our state. While recent relief is a good start, families need permanent solutions, not temporary fixes. That's why AFP North Dakota is pushing for meaningful, permanent property tax reform, so homeowners can plan for the future without worrying about being taxed out of their own backyards. Learn more about the road to opportunity and our plan for property tax relief at afpnd.org.
This episode is presented by Recovery Centers of Montana.
If you or someone you know is struggling, getting help shouldn't feel out of reach.
Recovery Centers of Montana offers care across 6 locations, including inpatient facilities and outpatient clinics.
Step away from the noise and focus on getting your life back on track.
Learn more by calling 701-401-3000.
That's 701-401-3000.
Well, we finished up our interview with Ari Johnson, who is running for Watford City Attorney. He's been in private practice. He's worked as a state's attorney. He's running for state Supreme Court against Justice Tufte. And you brought up a really good point, Ed, that we do actually have 2 state Supreme Court justices. One because Justice Bahr, Justice Doug Bahr, was appointed. And so, of course, North Dakota law says after an appointment like that, they do have to appear on the ballot to have the appointment essentially confirmed by the voters, and then they complete their term. So we have a full, complete 10-year term. That's what Mr. Johnson's running for against Justice Tufte. And then Justice Bahr is running unopposed to have his appointment to the court confirmed. Good interview with both. You brought up a really interesting point about these nonpartisan races. And it's not just, it's the judicial races. Also, you see it with the superintendent race on the statewide ballot, where essentially they appear on both ballots. They appear on the June ballot, and then they appear on the November ballot. Now, the June ballot is sort of a winnowing. The top 2 vote getters on the June, for all the partisan candidates, the winner there is the nominee. So if you're the Republican candidate for governor or attorney general or whatever, you're running against other Republicans or other Democrats or other libertarians, as the case may be, for the nomination. But for these nonpartisan ballots where there's not a nomination, basically we take the top 2 vote getters, they advance to November. Your point is, you made a point while we were off air, which is that if we only have 2 candidates in the race, why do we need them on the June primary ballot? I think that's a really good point.
Well, I find it interesting that the nonpartisan races in North Dakota, which include mayors and city commissioners and county commissioners and things, go on to the primary ballot. And often they're, as the Supreme Court issues, often they're unchallenged, or there's maybe like now we have one other person, so there are only 2. Well, now you have to go through the primary election. You have to spend some money to get your name out there because you want to be the top vote getter. You have to campaign. You have to do all the things you do, and then you just go off to the general anyway. So it seems to me, and it would obviously make a change in North Dakota voting law, but it seems to me if there are only 2 people who are certified candidates, why do you have to go to the primary? I mean, they have to go to the general election anyway. Why don't you just go direct to the general? It's kind of a burdensome issue to have to do 2 elections when you only require 1, but.
Well, I think also from the perspective of the voters, our ballots get very cluttered sometimes. I mean, we have, and I say that like these races are important, don't get me wrong. But the voters, I mean, you show up and, okay, I know who I'm voting for the legislature. I know who I like for the statewide offices. And all of a sudden I'm voting on like the soil conservation district or a lot of these other races. And it's like, I don't know. Like, first of all, some of them, I think sometimes maybe we just elect too many people. If the voters don't really know who the candidates are anyway, what are we doing? Is that even democracy? I don't know. And then the other, I think your point, maybe we just need the nonpartisan, particularly like these judicial races or whatever. Maybe we only need them on the ballot once. If there's especially if it's an unopposed race where there's only 2 candidates, maybe if you have like 4 or 5 candidates for a race and we're narrowing them down, maybe that makes sense then. But it seems like that would be an easy fix in the laws, just to say, listen, if they're running unopposed or there's only 2 candidates, they can just go to the November ballot.
Well, it seems like a waste of resources, both personal resources, financial resources, and the conversation in the public. I mean, you have to, the public has to do it twice for the same people. I mean, why don't we? And it could be the primary, it could be the general, either one. I mean, it doesn't matter. But one, like you say, one election instead of 2. This would make a lot of sense to me on some of these nonpartisan races.
Let's switch gears a little bit. Now, we got some pretty terrible news this last week. Representative Liz Conmey from Fargo, Democrat from District 11, passed away. She was in a plane crash and, passed away. Just terrible news. She was, as can be attested to by the outpouring of grief from both sides of the aisle. She was a very well-respected person, very well-liked. Her work as a legislator was widely respected, even by those who disagreed with her politics. So that was terrible news. I wrote something about the process because, when we have a vacancy in office like that occur, it's terrible, and we all need to take a moment to mourn, but also the people's business marches on. And so there's a process where we have to appoint someone new to take that space. Now in North Dakota, those appointments are made by district committees, but there's also the question, she was on the ballot this cycle. She's already on the June primary ballot. It's too late to take her name off. A lot of those ballots, by the time she passed away, had already been mailed out to members of the military. I think absentee ballots are going to be hitting our mailboxes starting this week. So that's tough stuff. And then on top of it, our term limits amendment that we passed a few years ago makes it a little bit tougher because she has an unexpired term. Her term that she's currently elected to expires at the end of November. So there's an obligation there to appoint somebody to fill out the rest of that term. The problem is a lot of people aren't going to want to fill out that term because under the current term limits law, that counts against you. Even though you would only be serving a few months or a few weeks, depending on when the appointment gets made at the end of her term, you would essentially, under the current law, be disallowed to serve another 4-year term. Because right now the law says you can only serve 8 cumulative years. That's 2 terms. But if you've already served a partial term, whether it's a few years or a few days, you can't be elected to 2 more terms because that would put you over the 8-year limit required by the law. So it's kind of a penalty, the way the current law is written, against people who take these appointments to fill vacancies.
Well, it is, and it's we in the conversation that we just had with Ariston Johnson, he said the one that's on the ballot you mentioned is only for 8 years, the other one's for 10, so those
in the Supreme Court races,
or election things, come to play. So there are a couple of issues here, and I can't remember totally for sure on all this stuff. But does in the case of District 11, do they have to make an appointment? Can they leave it vacant until after the general, and then either have a special election or whatever? I mean, do you have to have? Was one thing. The other is Liz is on the ballot, so in that district, absent a write-in candidate who has some power, which usually they don't, she's going to get elected. Well, then what happens? So she's an elected official but can't serve. So then does that count for the term limit?
Well, so the Secretary of State has said that even if Conmey wins on the primary, because she's on the primary ballot now, and that's for the Democratic nomination for that seat, Democrats are going to run a write-in candidate. And if that candidate wins, then they're going to go forward. And they're going to be that candidate, the write-in candidate would be on the general election ballot. If Conmey wins, even though she's passed away, she will not advance to the November ballot because she's no longer qualified for that ballot. She's passed away. So it could be that would just be on the general election ballot. The Democrats would probably have to run somebody as an independent. District 11, probably that's not going to be an issue because that's a very Democratic district. I don't even think there's one Republican legislative candidate in that district. She's running for the state Senate, not the state House. So those House members were essentially running unopposed anyway. So but there's a separate matter of the remainder of her term, which is who's going to be the representative from District 11, one of the representatives, until November 30. Now, you're right, Ed. Maybe they can leave that blank. The way the process works is legislative management, they have a 21-day window to make an appointment. That clock starts ticking when legislative management, the legislative management committee in the legislature, which is currently chaired by Senate Majority Leader David Hogue, when they notify the district Democratic committee that there's been a vacancy and you have to make an appointment. That starts the clock ticking on a 21-day window that they have to make an appointment. If they don't make an appointment after that, then legislative management committee, which is controlled by Republicans, would make an appointment. Now, I don't think that Senator Hogue's committee, I don't think there's appetite in there to do something that mercenary to like appoint a Republican for a few weeks or a few months. You know, I don't think that there's an appetite to do that, but that is sort of an impetus for them to make an appointment. But it does. And the reason why I brought it up, term limits issue, and why I think it's important is because we do have a ballot measure. The North Dakota legislature put a ballot on the November ballot. It's going to be Measure 1, wherein they address this issue. And they say that if you get appointed to serve a partial term, that doesn't count against your term limit. Frankly, Ed, I think that's good reform.
So we have this, constitutional amendment that the people of North Dakota passed on term limits. And I think that, that was important. People wanted the term limits, but, the term limits had some limitations to them that I think are detrimental to the way our legislature operates. And to get good policy out of there, get good legislation out of there, I think we really need to look at this constitutional amendment. And I would urge people to really consider what's going on structurally beyond just, do you want term limits? Do you want to kick people out of office or not, or whatever? Because, here's the issue. So you can be 8 years in one legislative body or the other. But, that's only 4 sessions. That's only 4 legislative sessions, not 8 years of legislative work. And so when you're in, 4 legislative sessions, the first legislative session that you're in when you're not familiar with the process and the things that are going on, you're reading 1,200 bills, you're trying to absorb it all. You're not the most effective legislator. The second time around, you start to understand the system better. And you also have to look at lots of times public policy takes more than one session to get in. I mean, it takes working on it this session, the next session, 2-3 sessions later, you finally get that policy on the table, signed by the governor or in front of the people, whatever the case may be. So, the process, I think the logistics of the legislative process is restricted right now with the 8-year limitation in each chamber. So what the amendment is asking the people of North Dakota, say, if you can serve 8 years in one and 8 in the other, total 16, why can't we serve 16 one chamber and one in the other? That makes a lot of sense to me, given the way that we generate public policy, the way we move forward, the way we get stuff done. It takes a long time. It takes expertise. It takes a learning curve. And to me, having people there a little while longer, and I appreciate North Dakotans' desire to have term limits, because I think some legislators get there to be too long. But logistically, the fact that we have legislative sessions every 2 years and that it does take 2 or 3 or several sessions to get good public policy generated and passed and signed by the governor, I'm just thinking that it doesn't change the amount of time someone can be in office. It only changes the amount of time that one can serve in a singular chamber, and that makes sense to me.
That's a really good, because under the current term limits that are the law as passed by the voters, legislators can serve 16 years. And I should be clear, the term limits apply to the governor and the legislature. Essentially you have, for the legislature, it says you could serve 16 years, but you can only serve 8 in one chamber. So what Measure 1 does, that's what the legislature's put on the ballot. What Measure 1 does, it says, we're going to keep that total 16-year cap, but we're going to say you can serve all 16 years in the House or all 16 years in the Senate. And once you're done with those 16 years, you're done. However, you split them up between the House and the Senate. The other thing it does is it says if you get appointed to fill out a partial term, that doesn't count towards the term limit. And I like that for two. First of all, it makes it more likely that somebody, if we have a term, with Representative Conmey's term, there's only a few months left. But sometimes if somebody has to step down or passes away early in a term and they get appointed and there's like 3 years left, well then, I don't think that should be held against them for term limits. They should be able to serve, 2 full terms. So what Measure 1 does is says that doesn't count. The other thing I like about it is on the back end, Ed, where if you see a legislator pass away and we're looking for a placeholder until we get to the next election, it'd be nice for them to be able to choose a legislator with some experience to say, come in and fill in during this, you've already been here, you've already done it, you know the ropes, come in and fill in for this legislative session, and then we'll appoint somebody, or elect somebody in the next election to replace you. I like that a lot better. It gives us some more flexibility to make sure that we're getting experienced people in, keeping experienced people in. I think it's good reform. A lot of the reaction to it, though, has been, these evil legislators are out to dunk on the people or to take the people's voice away. That's a lot of the reaction I'm hearing to Measure 1. And I think that's unfortunate because, honestly, I think it keeps the spirit of what the people did and just makes some improvements on it.
Well, it's and you want to keep that spirit, but the reality is what was passed by the people and put in the Constitution functionally is affecting the ability of the legislature to develop good public policy. And I think you got to look at beyond, I don't like my legislator being in there too long, or they get corrupted, or they don't represent the people anymore. You have all that, for sure in the conversation, but let's keep the conversation on how do you develop good public policy. Good public policy goes over time, and we need people to be understanding, developed, tuned into how the legislative process works, and to understand the complexities of public policy that take a long time to develop. And so, and to me, it still follows the people's will. It allows somebody to serve for 16 years, but it allows them to serve in one area that might be more beneficial structurally for developing good public policy.
Let me ask this question, and I wish we could have asked our judicial guests about this, but obviously they can't comment on it. But there is a legal challenge before the courts because the constitutional amendment that was passed by the voters included a provision, and I think this provision absolutely stinks, but it includes a provision that says the legislature's not allowed to propose amendments to that portion of the Constitution. Now, the legislature's argument is we can't amend the Constitution. The only people who can amend the Constitution is the people. We can propose amendments, but their argument is we're not amending the Constitution by proposing an amendment to this part. We're asking the voters to do it. That's their argument. But what do you make? There is an attempt to try to pass things at the ballot and then lock the legislature out from tinkering with it. And again, I get you don't like the legislature, you don't trust them or whatever, but we're running into a problem, Ed. I don't know that we can, if the courts allow that to stand, I'm afraid that every ballot measure we get is going to have language like that says the legislature and the governor can't sign a bill to ever amend this part of the law. We're going to reach a point where what's the point of having a legislature? Yeah. I guess we'll just have to do everything at the ballot box.
Well, and that's what happens in the end. I mean, that's the finishing touches of time, what will happen. That's it. It's an interesting piece. And I think, first of all, as I agree with your argument that the legislature isn't making this decision. The legislature is asking the people to make this decision. So, that's an issue. But do we understand when we're voting for stuff like that, when we're in the ballot, do we read that whole thing? Do we read totally all the language? Do we say, hey, I agree with term limits? And certainly, Rob, there are issues here where you question the legislature's actions. On the Ethics Commission, it was passed by the people. The legislature came in, tried to change it or maneuver it or, did it around. So people go, oh, they can't do it again. We're not going to let them to do it with term limits. On the other hand, I don't believe constitutionally and in a republic, a democratic republic, that you can restrict future actions of the legislature. I mean, how do you do that? They represent the people. In this case, they're putting it in front of the people. Yeah. I mean, how can you possibly restrict the legislative body from doing their jobs? I don't. Well, right.
The legislature itself can't do that. They can't write a law and then say it's also illegal for any future legislature to reform or to repeal this law. As governor, you couldn't have issued an executive order and then said, and it's also illegal for anybody who succeeds me in office to ever overturn this executive order. That's not how democracy works. And yet at the ballot box, they're trying to do that. They're trying to say, okay, well, we passed this law and now we've also made it illegal for any other branch of government to ever touch this law, that I don't think is in keeping with the reality of how our republic is supposed to
Well, I would have liked to do that, Rob. On the executive orders, not
Yeah,
allowing
yeah.
anybody. That would have been a good deal. But you can't do that. I mean, it just doesn't work.
Yeah.
You can't. We have separate branches of government that are constitutionally required to do their jobs, and in the legislative situation, it's to provide public policy, is to generate public policy. And how can you say we're going to restrict the legislature from doing their jobs, from generating public policy in the future? I don't see it. Now, I'm not a lawyer. I don't know the language. I know some good, solid lawyers who are concerned, that the people passed that and that piece of legislation is in there. It would be interesting if we could go back and do some polling, to see how many people voted for term limits that knew that provision was in there.
Yeah. Well, I mean, we actually had some polling. I mean, the legislature they commissioned a study, and part of that study, they did some public opinion polling. And what we found, not surprisingly, is like 80+% of North Dakotans support the idea of term limits. But a lot of them were confused about who the term limits applied to. They thought the term limits applied to Congress. They actually apply to the legislature. So, and again, I don't want to insult the intelligence for the voter, but as we were talking about, sometimes they get that ballot. There's a lot of stuff on there, and they're not necessarily going to be up to snuff on every issue. I mean, I'm very skeptical of the initiated measure process. I don't really like it that much. That being said, I understand there's a need sometimes that the legislature's not being responsive, if they're skipping over an issue that the public's really passionate about and they're just not taking it up, or they pass something that the public really finds pretty odious. I like the idea of referring things to the ballot or bringing issues to the ballot. I guess that makes some sense. But in this instance, you can't go the other way. We can't just lock it out and say, well, this is the only process that matters. I think we're best served when all of these processes are open. And again, like the three branches of government, the judicial branch, the executive branch. I mean, I guess the people are kind of another branch of government when they choose to legislate at the ballot box, but it's not good when we decide any one branch of government gets to rule supreme over the others. They're separate and equal, and I think the same goes for the ballot box.
Yeah, well, I'm different than you, as I love the initiated process, and because I think it's a people's government, and I love people being able to do it. But there are some issues here that we have to be responsible to. One of the items that's on the ballot in the June primary is a single issue constitutional amendment change. And so in this case, like I say, how many people knew that this restricted or tried to restrict future legislative action versus just straight term limits? So, I think single issue, which is on the primary ballot, single issue vote single issue on initiated measures, constitutional measures, is important, because that allows the people to know exactly what it is. They can look at it. There's not peripheral issues or or unintended consequences. There's this strict thing that you can vote on. And if
I am smiling a little bit about the legislature putting a single issue amendment on the ballot after the courts smacked them down for violating the single issue. The court struck them down because they were using like the Office of Management and budget and had like a Christmas tree and hanging every ornament. They weren't following their own single issue, and now they're putting it on the ballot. That is a little hilarious. That being said, I don't want ballot measures to be Christmas trees either. The legislature should have been following its
two
single
wrongs
issue.
don't make a right, Rob.
Exactly
Two
right.
wrongs don't make a right.
They do not. So
it can't be, it's confusing. And so, anyway, we were talking about the term limit situation, but I think single issue ties into that in this case. The other thing is, and the initiated measures, Rob, transparency. I mean, you and I have talked about transparency in the past. I mean, you get some millionaire or billionaire out in California, decides he wants to do something, comes in there, overwhelms the people of North Dakota with flyers in their mailboxes and advertising on TV and radio and this and that, and they vote for it. And it's never even anything that was asked for or even relevant sometimes in our state.
Well, I think we saw that with Marzy's law. Yeah,
people should know where the money's coming from.
Yeah,
absolutely.
Yeah, we saw that with the California.
So I believe in the initiated measure, but I think there are some issues here that we should clean up that make the initiated measure better and more responsible to the people.
I believe in checks and balances in every aspect of government. I don't think any one route to making law should be the route. So checks and balances on everything. Checks and balances on the legislature, checks and balances on the governor, checks and balances on the judiciary, and checks and balances at the ballot box too. I think it's got to be that way across the board. Yeah, our initiated measure process could use some work. Ed, thank you so much for sitting in this week. I really appreciate it.
You bet. It was fun to be with you, Rob.
Absolutely. Right. Well, we're going to put a pin in it there. Remember, you can follow Plain Talk ND on social media, Facebook, all the things. TalkND.com is our website. It actually goes to our YouTube channel. Subscribe to our YouTube. It's a great way to follow the show. Also, remember, if you ever want to join the show, you want to send us a text, leave us a voicemail, 701-587-3141. Thanks so much for listening. We'll talk again. That's it for today on Plain Talk, the voice of North Dakota politics. Plain Talk is a production of Forum Communications Company. Got a question, comment, or suggestion? Leave us a voicemail or send us a text message at 701-587-3141. That's 701-587-3141. If you haven't subscribed to Plain Talk yet, you can find us on YouTube or your favorite podcast platform like Spotify or Apple Podcasts. For those of you who are already hooked, give us a rating or review. And don't forget to share or tell a friend. Special thanks to my co-host Chad Oban, and from myself and everyone at Plain Talk, thanks for listening.
We'd go to the Red Pepper on the way into town at my insistence, possibly somewhat inconsiderate of my grandmother cooking a nice meal that I was no longer hungry for after my salami grinder.
The North Dakota oil and natural gas industry works here, and works here, and here, and even works here by creating 60,000 jobs statewide and generating billions of tax dollars annually to support our infrastructure, flood protection projects, and our schools. North Dakota Oil and Natural Gas, advancing the possibilities.
Learn more at ndpetroleumfoundation.org.
Dear Mrs. Landis, you have a gift for recognizing students as individuals and cultivating the abilities we don't yet see in ourselves. Alongside the success I found in the classroom, I learned the importance of trusting my own voice. I've carried a sense of confidence and a commitment to intellectual growth into every opportunity I've pursued since.
Sincerely, Alexis. Thanks, Alexis. Of course, thank you.
Public schools teach important lessons, and they also get us ready and give us confidence. North Dakota Public Schools are an investment in our future.
This episode is presented by Recovery Centers of Montana.
If you or someone you know is struggling, getting help shouldn't feel out of reach.
Recovery Centers of Montana offers care across 6 locations, including inpatient facilities and outpatient clinics.
Step away from the noise and focus on getting your life back on track.
Learn more by calling 701-401-3000.
That's 701-401-3000.